So for those in the audience watching us on WebEx, we had an issue with the internet. We are back up and running. Councilor Dumanville called in and said that he's in favor of the Freeman's appointment to the judiciary and will be supporting him next week. I'm sorry I had to interrupt your presentation just when you were on a roll, but I think it's important that all of our folks that are looking now today or sometime in the future can hear what you have to say. So if you start where you left off, that would be great.
Sure. Thank you, Councilor. Most of what I'm going to tell this council today has very little to do with me. It has to do with my family legacy and how that has shaped who I am. Jackie Robinson once said, "A life is not important, except in the impact it has on others' lives." It was a phrase my mother had quoted to me often as a child. I heard it so much, quite frankly, I was sick of hearing it. I think my mother repeated it so often because she wanted to make sure that I never forgot the concept. And to this day, I never have. My parents, Donald Freeman and Bertha Freeman, were both born and raised in the South. My mother was born in Statesboro, Georgia. My father was born in Claremont, Florida. My parents were raised during the days of Jim Crow, which means they have a vivid recollection of the days of segregated schools, buses, water fountains, and restaurants. My parents grew up believing in two truths: that education was a great equalizer, and that a commitment to public service was the only way to make the plight of the people in your community better. My parents certainly reinforced my values, but my belief system certainly didn't begin with that. It began with my grandparents. My grandfather, Harvey Van Buren, was born in South Carolina. He became the first physician of color in the town of Statesboro, Georgia, and he opened the first hospital for African Americans in his county, Bullitt County, Georgia. Before that, he put himself through high school and college, then medical school at Howard University. My grandfather served his community, performing hundreds of surgeries over the next 2 decades. He even turned down offers for more money to practice medicine at a prestigious neighboring all-whites hospital. His dedication to his community was too important for him to leave. He felt he owed an obligation to the people of his community. The dedication to education and public service in my family originated with my grandparents, but it certainly didn't end there. My parents met in college in the 1960s. My father attended Morehouse College, while my mother attended the neighboring all-women's school, Spelman College. While in college, my parents, seeing the civil unrest that was engulfing the nation, became involved in the civil rights movement. My parents knew college students played a pivotal role in the movement and felt a strong obligation to get involved. Many years later, my mother would graduate from Spelman College, and she continued serving her community for the next 30 years as the executive director of an inner-city job skills training program in Hartford, Connecticut. My mother was unfortunately diagnosed with liver cancer in 2010. She passed away the following year, but my mother's commitment to family and community, I learned through my mother's commitment to family and community, I learned the importance of compassion, empathy, forgiveness, patience, and the need to continuously strive to be a better person. Essentially, all of my virtuous traits that I have come from her, and I wouldn't be here today if it wasn't for my mother's compassion for people and her huge heart. My father graduated from Morehouse College and attended the University of Connecticut School of Law. My father spent the majority of his career serving the inner-city Hartford community, whether it was through criminal representation or the drafting of wills. My father in the early 80s was the quintessential general practitioner. And as you can imagine, with this legacy of education and public service as the backdrop of my life, it's probably no surprise why I sit here today. The countless lessons I've learned over the course of my life places me in a position where serving the public is essentially a calling that I'm driven to fulfill. From stories of civil rights marches and protests, I learned about courage, resolve, and self-sacrifice. Through stories about my grandparents growing up in the South, I learned the value of education, dedication, and hard work. From my parents' stories of service in the inner city, I learned lessons of hope, second chances, and the power of redemption. And my entire legacy has taught me the need to pay it forward and give back to my community. After law school, I worked for my father in a small law firm. I then worked for the district attorney's office, and I worked as a solo practitioner for the last 16 years. I have practiced criminal law as well as personal injury in both Connecticut as well as Massachusetts. I have served as a magistrate. I have worked on many boards of directors, and I've even coached Little League. All of these experiences has given me the unique perspective that I wouldn't have otherwise had. My professional and personal life experiences has helped shape me into the well-rounded, even-tempered, hardworking, and compassionate person who has lived through and is aware of the hardships facing the criminal justice system with a resolve to tackle those difficult circumstances head-on. Each role that I have taken over the last 20 years has prepared me for the role of Associate Justice in the District Court. It has given me the experience, the patience, the perspective, and the sound judgment needed to be an Associate Justice. I am honored by this opportunity to become an Associate Justice and hopefully make an impact on the people of Western Massachusetts. I understand that with this position comes tremendous responsibility. It's a responsibility that I will never take lightly or take for granted. If confirmed, I will approach every day understanding that the District Court is the people's court. And every case that comes before me is enormously important to the person on the other side of the bench. And therefore, my full attention, patience, and consideration is required. I feel that as a judge, that is a requirement. I now look forward to answer any questions that you might have about my background, my qualifications, or any other questions this council might have. Thank you.
All right, thank you very much. Before I go into questioning, I would indicate that Brandon Freeman appeared in front of me many times. And I support him completely. Does a great job, great demeanor, always prepared, gets the issues, nails them right down, and is a very effective litigator for his clients. With that said, I would ask Councilor Ferrara, do you have any questions?
Thank you, Madam Chairwoman. Thank you. We had a very nice conversation over a week ago, and I was impressed with what you said. I didn't understand how much practice you did in Connecticut compared to Massachusetts.
I would say the split is probably 75-25, 75 Massachusetts, 25% Connecticut.
And that's where you were a magistrate for a while in Connecticut as well.
Yes, that's correct, Counsel.
And roughly, how many trials have you had over the last 20 years, I guess?
In my application, I put 30 to 35. That's probably a conservative estimate. I didn't want to overestimate, certainly. I would imagine that as a prosecutor, I probably had 30 trials alone as a prosecutor. As a defense attorney, I probably had roughly another 20 to 25. So a more accurate estimate would probably be in the neighborhood of about 60 criminal trials. I've also had one civil trial.
That includes jury, mostly bench or jury trials?
I would say mostly bench.
Interestingly, so I've been on for 8 years now. And last week we had a person answer that they didn't think that the judicial compensation was adequate, which was the first time in 8 years. You said in all candor, you don't know. So this is the second time in 8 years that I've seen, everyone just usually says yes, and that way it's not an issue. So I'm curious about why is it you don't know?
I think until you're into the role and you know what judges have to deal with on a day-to-day basis, I know it's more involved than just what we see as attorneys appearing before judges. I know that there are outside meetings. I know there's a bunch of other areas of being a judge that judges are involved in. So in terms of whether the compensation is adequate, I don't know if I would be in a position to answer that question until I'm actually in the role. And then once you're in the role, I think you'd have a better idea of whether it's adequate or inadequate.
What do you think the average practitioner in Western Massachusetts makes overall?
The average lawyer,
Yes.
my guess is probably in the neighborhood of 80 to 90,000, I would think.
You know what a judge is going to be making very soon?
I had heard that with the increase, they're going to be slightly over 200,000, I think I heard.
Do you realize that a person in private practice, when you look at the health benefits, the retirement, and everything else, probably has to do about $400,000 a year to equal the $200,000 that a judge will get paid?
I would. Sorry?
Do you agree with that?
Agree with the.
That a person in private practice, in order to save enough money to get the retirement that a judge gets, would have to be making about $400,000 a year to equal out.
Right, I would say that's probably accurate.
With that in mind, do you think $200,000 is adequate pay for a judge? District court judge?
It's probably too much.
That's first in 8 years too.
Your wife is gonna.
Counselor, I may need a ride home after this.
I think your resume is incredible. Your story, your generational story is tremendous. It's hard to imagine, what your ancestors went through. I put a lot of faith and confidence in my counselor to my left here, who served on a district court for almost 20 years and was the mayor of Springfield. And she's been around the block, let's say. I'm not saying you're old, I'm saying you're experienced. And she has, talked about you incessantly since the day you got nominated, the judges that you had appear before us, the people that you brought today. It looks like you have a wonderful family here. Do you think you should be a judge? Yes? All right. Well, I don't know. That was
Kind of lukewarm.
Honey, you know that? But I do, in my heart, believe that you will impact the next generation, and you'll have a good effect on people. So you absolutely have my support next week.
Thank you, Counselor. I appreciate that.
Counselor Devaney.
Thank you for all the time you afforded me. Long way to come to Watertown, but you went to school right around the corner from me, guys. So I just want to say that I was very impressed, and what a wonderful family you have. I mean, of service, and to undergo all of the what they had to go through and to succeed. And I have to tell you, in 22 years, this is the only application for a judgeship that included a biography for somebody else. Not you, but somebody else. But you know what? You have reason to be proud. Imagine in those days, your grandfather was the first black doctor. That's incredible. My father in those days was probably the same age. My father went to the 8th grade. And that was in Italy, and never got any education here, and that was the end of it. So imagine him through all of the roadblocks, he did that. That's remarkable. So I have to say that. But you have had a very supportive family. Also, you got a very supportive counselor, and you have told me that Counselor Hurley urged you to apply for this position, and she successfully urged you, and you're here. So I want to ask you, when did you apply?
I applied in March of 2021.
And when did you get interviewed?
I interviewed with the JNC a year today, so May 4th of 20.
May 4th. Wow, that was quick. Yeah, that's good urging. But what I wanted to ask was, you're applying to the Superior Court, right?
My application was towards a Superior Court vacancy.
Okay.
But my understanding is the appointment is for district court.
As though the district court. Okay, because I question that, because you've had 68% in the district court and only 30 in the Superior Court, and I thought the best fit would be district. And I don't know, it seems to be in my 22 years, the philosophy I hear from people, the district court is the people's court. And those, they don't want to be in any other court. Now, I question about your connection with Connecticut. You would have been a judge if they had applied, if you had approved you in Connecticut. So tell me, why is that Connecticut connection? You grew up there and everything, and you're a magistrate there. So tell me that connection, because I'm trying to figure that out with you. Obviously, if you're brought up and you go to high school and you're brought up in Connecticut, you have a special feeling for Connecticut. So did you have a special feeling that you'd rather be in a Connecticut court? Obviously, you didn't apply to Massachusetts, you applied to Connecticut. So tell us about that.
Sure. So I applied for the Connecticut bench back in 2013, and I wasn't selected for an appointment at that point. My wife and I have.
Did you have an interview?
I did not. The process is a bit different in Connecticut, so there was no interview at that point. So my wife and I've been a part of the Massachusetts community from a professional perspective for a long time. I opened my office originally in 2006, as Judge Gross had pointed out before. We were law partners for about 9 years, and then when he took the bench, I've been in Massachusetts for another 10 years since then. So I've been a part of Massachusetts. I've been a part of many boards in Massachusetts for a long time now. My wife and I had considered moving to Massachusetts on several different occasions over the years. But my kids were small at the time, and my in-laws, as well as my parents, were in Connecticut. So my wife had asked me, while the kids are young, and I'm working to 6:30, 7 o'clock some nights in the office, my wife said, listen, I'm gonna need help with the children. So if you're gonna be in the office, I'd like to remain in Connecticut for a little while, at least while the kids are little, so I can have the help from my in-laws and from your parents. So that was certainly a request I couldn't refuse. But the intention was always to move to Massachusetts.
When did you move to Massachusetts?
January of 2021.
2021.
Correct.
So in the past 7 years, you've been a magistrate in Connecticut.
I was a magistrate until at some point during the pandemic, when they.
Yeah, well, your resume says 7 years that you were there. Yeah, so, okay, so 2013, you're a judge in Connecticut.
I applied.
You applied
Correct.
and you were rejected from Connecticut to be a judge. You were 45 years old. What's the process? Did you go through a JNC there, or how does it work?
So the way it works is there is a body similar to the JNC in Connecticut. I did appear before that body, I presume sometime in 2013. I passed that hurdle. At that point, your name basically goes onto a list that is sent to the governor's desk at that point. And you were on the list with several other people, and then either you're selected or you're not selected. So I wasn't selected.
So you decided to move to Massachusetts. Okay, so tell me, some of your cases, I didn't get a result. It was kind of hard to figure out. There were like 2 sentences. So maybe you can tell me more about it, about what you look back as your most serious case, and it was the rewarding result.
I would probably say my most rewarding case was a case I had about 2 years ago. It was a young man who was charged with possession of a firearm. He was walking down the street with his girlfriend and his best friend. Just walking down the street, nothing illegal going on. A car pulls up next to him. An individual gets out, immediately pulls out a firearm and starts firing at the 3 individuals. My client's friend was immediately shot and killed right there on the spot. My client and his girlfriend then ran behind a car to seek refuge from the firing. As the perpetrator came towards my client, presumably to finish the job or execute him at that point, my client then pulled out a firearm that he had and returned fire. And that's probably the only thing that saved his life, is that he had a firearm on him. The police came shortly thereafter. And they ended up arresting my client for possession of a firearm because he didn't have the proper licensure for that particular firearm. So the Commonwealth then filed a motion for 58A, a dangerousness hearing, to try to incarcerate my client. So I represented the client at the dangerousness hearing, and effectively I made the argument that had my client not had a firearm on him, there would probably be 3 deceased people instead of 1 deceased person. So, quite frankly, I didn't know if it was an argument that was going to prevail in front of the judge. I thought it had the benefit of being true because the whole interaction was caught on a surveillance camera from a local house. So there was no dispute in the facts. So what my client had relayed to me was in fact the truth, that he pulled out a firearm to defend himself, but that doesn't absolve him of having a firearm without an FID card. So I was able to convince the judge that, but for this individual attacking my client and his girlfriend and his friend with a firearm, that my client wouldn't have engaged in that type of conduct. And the judge, after argument, the judge was willing to not hold him on the 58A. So I thought that was a rewarding end to that case, because I thought this was an individual that, other than having a firearm on the street without a proper license, was not involved in any other nefarious behavior and would not have engaged in that conduct, but in an attempt to defend himself and his girlfriend.
you know, the council has voted a rule that we're timed, so I want to go on. Now, one of the cases that really concerned me, because I had a friend whose baby was killed by shaken baby syndrome. Very hard to determine if a baby that is injured or who's died, it determines whether it was legitimately an accident that the child was responsible for, or was it a perpetrator? This case concerned me. You had a woman who was accused of abusing her 11-month-old baby. So tell us about that one.
So I represented a young lady who had presented to the hospital, I believe, with the baby had some bruises to her face. And the hospital had done an evaluation on the young child. And someone at the hospital had determined that essentially, but for physical abuse, these type of injuries wouldn't have reflected on the child. So they contacted the police began an investigation. They originally believed that my client's boyfriend was the suspect. They questioned my client. My client said, my boyfriend hasn't been around the child for a while. So at that point, the investigation turned to my client. So in representing my client, I was able to get an expert out of Rhode Island that examined the medical records and was able to determine that, at least in her medical opinion, that these type of injuries could have presented themselves but for abuse. In other words, the doctor believed that there could be some other cause for the injuries to the baby other than physical abuse. So once I presented my report to the prosecutor, along with the fact that my client had no prior record, she was a young girl, and she came into my office with her head in her hand. She was really sad about what happened. She said, I would never abuse my child. I can't tell you how this happened, but I could tell you I would never do something like that. And she said, I'm really not interested in a plea on this case because I really didn't do anything. And so as I outlined in my application, she was adamant about not entering a plea. So all along, this was either going to be a dismissal or it was going to be a matter that was going to result in a trial. So fortunately for my client, the prosecution believed the information that I presented them, and they were willing to no prosecute.
Those cases concern me, and we haven't got time because we're timed. The Eaton case, if you remember that case, and that was a babysitter from England, 18 years old, and she used to go to plays rent every night until 3 in the morning. And I know as a mother, you can't get up in the morning at 6 o'clock with a child and be sane. And so we can't get into it because we don't have time, unfortunately. But anyway, I am concerned about that because there's no witnesses. There's no witnesses in those cases. So it really, really concerns me about the children because we're having too many children that are dying or abused. And I just think that something has to be done about it, but can't go into that now. I want to say, and I feel like the Federal Express man, I can't read it because I'm timed. They're timing it because I asked too many questions. That's what this is about. So anyway, that's why they put that 7-1 vote. So I want to tell you, you got wonderful letters. I wish I could read them, but I will tell you that Judge Williams, talked about you and said that in observing you, that you have taken on complex cases and you develop positive relationships with courthouse staff and litigants. That means a lot to me, that you care for people that are working in that courthouse. I'll tell you, that means a lot to me. I ask that a lot of the people when I'm doing my due diligence, okay? So you have been intellectually curious, a tremendous advocate to the clients and to the court system, calm, steady, and I can't read it all, but then Judge Santa Niello, and he said great things about you, and that talk about you're a solid family person, and we see this here. And I'm so glad that you were allowed to bring them. We had Judge D'Angelo who's not allowed to bring anyone, nobody. So we should be fair to everyone that comes in. So they were fair to you, and that's good with me. So anyway, you have, you will be an excellent addition to the district court, and he said more things about you. And then we had a lawyer, Joseph Bernard, who talked about you, and he said that in your careers, you exchange ideas, tactics, strategies with one another, and you call each other for advice and guidance, and your judicial community, your reputation is second to none. Can't get better than that, you know? And could not imagine a better choice for associate justice. His reputation, intelligence, demeanor, successful associate justice, I fully support the confirmation. And then Attorney Bailey. And Attorney Bailey talked about...
Judge Bailey. He's a judge.
Oh, my goodness, how did I do that? I'm tired. Judge, how do I know? I know him well, and he does a wonderful job, and I want to thank him for his service. And he talked about how impressed he was with your first evidentiary hearing. Do you remember that one? Well, you made an impression with him, so you have to think about that one. So he said that you would be, that I could tell then he would be special and look forward to observing him in the future. That's something, first time. So he said, you're so qualified, you're consummate professional, you work hard for clients, conscientious, and you're thorough, prepared, effective in your performance, keen legal, and counsel one another on complex, and well, I don't know, you can't say enough.
Excuse me.
In closing, this is awful. This is awful to be timed. I can't tell you after the pressure. But anyway, I wish I could read it all. The next one is a lawyer. I had the two letters confused. And
Excuse me.
a lawyer, and
Counselor Devaney.
this lawyer is
Counselor Devaney.
yeah,
I'm letting you know that your time is up.
terrible rule. Terrible rule. I have. We should talk as much as we can.
Excuse me.
You're qualified.
Excuse me.
That's the rule.
Counselor Kennedy.
Thank you. Our 15-minute rule, if every council takes 15 minutes, the hearing would go 2 hours, plus witnesses, plus statements. So it allows for, and there's no real limit on the time of the hearing. It allows for at least 2.5, 3 hours worth of hearing time, which is plenty of time for any nominee, especially given the amount of time we spend outside of the chamber, as I did speaking with you on the phone, getting a lot of information. I do have some questions for you.
Right to know.
Do you think that 58, that dangerousness hearings, do you think they're overused?
I do.
Okay. That's good. I'm glad you said that. And I want to talk to you about one specific aspect of dangerousness hearings, which I find incredibly troubling and had an experience with it yesterday. That's the 3-day hold. When a prosecutor files a motion for a 58A hearing. Is it your opinion that it's an automatic 3-day hold?
That has always been my opinion per the statute. I believe the statute read that upon filing of the motion that the individual shall be. And I think shall was interpreted to mean essentially has.
Assuming that the prosecutor has good cause to not be ready that day.
Correct.
And I have yet to find a judge who doesn't find good cause not to be ready that day, which I think frankly is outrageous. I had a case myself very recently, a 54-year-old woman who had never been arrested in her life. She was a secretary for a local lawyer for the last 30 years. I've actually known her for 30 years. This woman was locked up on Thursday and get out yesterday because she had an argument with her daughter that resulted in some pushing. It's shocking that that might happen somewhere in the world, that a mother and daughter might have an argument. The Commonwealth filed a motion for detention. I appeared yesterday on that case, and she was released on conditions pretty quickly. Horrified by the 5 years she spent in jail, a 54-year-old woman, never been committed a crime in her life. Afraid to shower while she was in jail, afraid to do anything at all except sit in a cell and cry for 5 days. And the DA said to me, this is probably gonna end up being a quaff or a dismissal. Well, they kind of knew that Thursday before I got, you know what I mean? You know, if it's a pushing between a mother-daughter, you know where that's going. Eventually, they're gonna make peace, and probably nobody's gonna be testifying, right? That's your experience over the years, right? Why should a 54-year-old woman be held in jail for 5 days, who's never been near a jail, near a police station, or committed a crime in her life because of an argument with her daughter? Do you think that's right? Okay, now you're sitting there and you're the judge in that case, and I use that as an example because it's a recent one. I bring it up all the time, this issue. It just really, to me, highlights it, that it just happened. You're the judge, DA, you see a fight with the mother-daughter. Judge says, DA files a motion for the dangerousness, okay? You're gonna hold that woman for 3 days or 5 days because of the long weekend?
I would certainly inquire with the Commonwealth as to why we can't go forward on that particular day.
Okay, so they say, well, we haven't talked to the victim, or she's not here, so we need 3 days. They always go forward on the papers anyway, but you know where that case is going. You know that person's getting out in 3 or 4 or 5 days, whatever it is, right? Right, when you're sitting there as the judge, you know you're letting that person out 3 days from now, right?
It would certainly appear that way, yes.
Yeah. Are you gonna have somebody go to jail who's looking at worse, the continuance without a finding?
I think certainly that provision within the law, the 3-day hold or 7 days for a defense attorney, I think is an unfortunate provision within the statute.
So why don't you hold their feet to the fire? I'll see you at 2 o'clock this afternoon. Get the person in there if you're gonna put them on the stand. Or go forward on the papers, which is what you're probably doing on Tuesday.
That's certainly what I would do. I would try to get that matter heard before the court as quick as I can.
Okay, so now they say we can't get it done. You know they're gonna be going forward on the papers. What are you gonna do? You're gonna send that poor person to jail for 5 days who has no idea what a jail is like? It's just not part of that person's world?
I would certainly see if there's any possibility of sooner than 3 days. I would say, how about tomorrow at 9 a.m.?
Well, then you send her to jail overnight. You're taking her freedom away for a night. You're locking her up in a cage overnight. Right? You think that's right?
I don't.
You as a judge can put their feet to the fire. You can say, go forward now. Right? You know what's gonna happen. And I'm distinguishing that situation from the real domestic abuse situation that involves violence and history and restraining orders and things like that. Sometimes it might be necessary, but you're the one on the bench that has to figure out when it's necessary and when it's not. Do you think prosecutors abuse that? The filing of that motion?
I do. I think it's an overfiled motion for sure.
What are you gonna do about it?
Certainly, I would do, Counselor, exactly what you said. I would try to, I think you're bound by the law, so,
You keep saying you're gonna try. Why can't you just do it?
because I think you're restricted by the law. I think,
I don't think you are. They have to show good cause why they can't go forward that day. It's not, my problem with judges, and I have a lot of friends that are judges and people I practice law with, my problem is they're just dismissive of that good cause provision. They're just dismissive. Oh, DA wants 3 days, they get 3 days.
I agree. I do believe that a lot of prosecutors think it's a given, that if they request the 3 days, they're automatically entitled to the 3 days without taking into account the provision.
So why don't you say, no, I'm not giving you 3 days, let's do it now.
I would certainly inquire with the Commonwealth as to what's the basis for the need for the 3 days, or even.
The victim's not here, we can't talk to her.
I think in that instance, if they request the 3 days and their basis is that they haven't had contact with the victim, I would certainly inquire as to, well, what attempts have you made to get a hold of the victim?
We called, we got a voicemail.
I would say, can we put this matter on for 2 o'clock? I would ask that the victim witness advocate in the DA's office continue to try, and we'll report back at 2
How
o'clock.
about this, why don't you send a police officer by her job or a house to see if she's there? If you need her here, let's get her here.
I think that's certainly something that a judge should do. I'm sorry.
Are you gonna do that?
I would, Counselor, I would. I think it's important that, to avoid the situation that you described, which is an
Nightmare. For that woman, that was the most horrible thing that happened in her life. It was absolutely the most horrible thing that has ever happened to her. It was traumatic. She didn't stop crying for 5 days. She didn't stop crying when I saw her down in the lockup. And then the DA, in a very cavalier manner, says, yeah, we're not going to vote. This is probably going to be a continued without a finding or dismissal. Do you think that's right on any level?
No, I think it's an abuse of the statute.
And it's an abuse of the statute that happens over and over and over in every court in the Commonwealth, every day. The DAs abuse it, judges let them get away with it, right?
I agree.
So I hope you're not a judge that's gonna let them get away with it.
I would certainly hold their feet to the fire more to try to avoid that the unfortunate circumstance where this individual is going to jail.
It's one of my pet peeves, I bring it up every time. Not just because I just saw an extreme example of it. I've seen it over and over and over, time and time again, on cases that people are never gonna go to jail on. Which brings me to my next pet peeve, which is bail revocations and bail revocations under 58A, dangerousness. Do you think that's an overused statute?
I think it has been, yes.
Okay. John Smith has a domestic, okay, pending. No other record. He was arrested for not operating after suspension. You gonna lock him up?
No, sir, not for that offense.
A lot of judges do. Some judges have the attitude that there should be consequences for committing a new act, and you should get locked up.
That could be the bail on the new case.
Well, the consequences could be that you get a punishment if you're convicted of the new offense. But how do you feel about scrams? Portable breathalyzers.
I've had a couple of clients on it. I know it's a difficult circumstance for them to have to continuously.
It's incredibly intrusive. I've had clients feel that are in their 50s that fall asleep at 9:30 at night, which I can't stay up till, and miss a scram at 10. You ever see that?
Yes.
And next thing you know, there's a warrant for their arrest, right?
Yes.
Your friend Joe Bernard and my friend Joe Bernard did a great job with the Anais decision. And what he was able to point out over the years that even though that we do a lot of work and spend a lot of money to have breath test machines that are supposed to be accurate, that are supposed to be properly maintained by the Office of Alcohol Testing, that are supposed to be, scientifically reliable and checked, right?
Right.
Okay, and Joe Bernard pointed out a lot of flaws with the machines that are subject to that statute and rules and regulations. You agree?
I do.
Okay. Who monitors these scrams?
It's a good question. I assumed it was.
I can give you the answer. No one does. No one. And people are getting locked up on these devices because they either miss one or they come out with a .01, .02, and it doesn't even go before a judge. A warrant is issued from some mysterious place in Clinton where they monitor these machines and whether people pass or fail them, right?
Right.
And there's a warrant for someone's arrest, and they're locked up. I had a guy in Quincy, was on a scram out of Woburn. It came out with a positive result at 6:30 in the morning. Police were there at 7 o'clock and took him to the police station. And what they did? They looked at him, they said, there's nothing wrong with you. It was a pretty high reading too.
Counselor Devaney, please
They
stop.
gave him a breathalyzer. I'm ignoring it, don't worry about it. They gave him a breathalyzer at the police station. You know what the reading was? 0. Okay, within 45 minutes, it was 0. He missed a day's work. He had to get hauled to Woburn Court from Quincy to get the warrant lifted. Okay, they're garbage, and I hope you are not somebody who is going to be putting people on a lot of scrams or GPSs. They can be an abuse too. What judges don't get, which Justice Gaziano said, you know, they're seizing somebody. They're taking them into custody when you put them on a GPS. You're intruding on their privacy. And he talked about how we should only be using those in very limited circumstances for a very limited purpose. To keep somebody away from somebody or from a certain area, and maybe for a curfew in place. You agree with me that judges put people on GPSs all the time when it doesn't seem to be a specific purpose?
I would agree.
You're gonna do that?
No, sir.
We had a great talk on the phone, okay? You have a very nice family, you have great friends. As Councilor Devaney pointed out, you have a stack of letters that are part of the record. We don't have to read them all in, we've all read them, and anybody in the public can see them if they wish. You are a stellar candidate. I enjoyed talking to you on the phone today. I've listened to what you had to say here today. I think you are going to be a great judge.
Thank you, Counselor.
I would absolutely vote for you.
Thank you, Counselor Kennedy. You have 2 minutes to spare. Counselor DiPaolo.
Thank you, Counselor. Good afternoon.
Counselor, good
You're
afternoon.
more than patient and persistent with me, and I appreciate it, and I apologize. I was really interested in Counselor Kennedy's line of questioning, as I often am, not being a criminal authority. I heard that you've been proactive about utilizing or pursuing the use of drug courts.
Yes.
Would that be accurate to say?
That is accurate.
Have you visited houses of correction? Have you had occasion to visit houses of correction?
Many times.
And kind of relative to discussing what I would agree is the overuse or misuse of dangerous mishearings sometimes. Are houses of corrections places that someone comes out better off, in your estimation?
In my opinion, not usually.
Why not?
Because I don't think there's enough of a rehabilitative aspect to the incarceration. I think many times it's more punitive than it is rehabilitative. And I think because of that, you don't generally come out better than when you go in.
And part of that's the environment, and as you indicated, or I infer, part of that is resources to address some of the issues folks are coming in with. I've heard, I've read, and I'm sure the data needs to continue to be analyzed, that there's been increased violence among youth since the start of the pandemic. So let's take for granted that early data is true. Why do you think, what would be a reason that might be happening, do you suppose?
I think maybe because of the pandemic, you have individuals in close quarters more often. And I think it may be just a simple function of individuals getting on one another's nerves. So I think that may be one factor.
I don't want to repeat some of the topics that have been talked about, but as far as the folks who are going to be before you in district court, and I'm thinking about those youth, and I'm thinking about the group homes they get sent to, many of which I think are even worse environments than some of our houses of correction, because similar to the instance that we heard you talk about prior, there's a lot of perceived need for self-defense and to be ready for self-defense. And there's a lot of ways that kids try to protect themselves, whether it be fleeing group homes, whether it be possessing weapons, that ultimately end up criminalizing them. When folks get into the district court as young adults, does their status as young adults impact I'm sorry, when folks end up in the district court as young adults and as a district court judge, does their status as young adults impact your discretion, do you think?
I think it would.
And how, why and how?
Well, I think why, because a lot of times you're getting individuals who come into the adult system, the district court, who are 18, 19, 20 years old. And I think there's a tremendous amount of research which indicates that individuals of that age their brains aren't fully developed yet. And I think, so you're gonna have an 18-year-old who runs into a stressful situation, whether they're encountered by some individual who may want to harm them or somebody that simply confronts them. And I don't believe that their brain functions how yours and my brain does. So their brain may tell them that, okay, the appropriate response to this stress is to attack or to take some aggressive action. Whereas if he were 30 years old, 35 years old, his brain may not tell him that that's an appropriate response. So their brains are not matured at that point, and I think that should go into a judge's determination.
So we might expect a 30-year-old to be better regulated essentially than an 18 or 19-year-old. And an 18 or 19-year-old is going to be more susceptible to influences of their environment, which is another reason that houses of correction often serve to increase recidivism when someone starts out as a young adult there. In your application, just want to flag two things, and I was interested in something that the judge said earlier, and it might have been during the previous hearing, but he indicated that from his perspective, he felt like attorneys of color who come before us as nominees are sometimes held to a higher standard, or at least there's a perception of that. I found that comment very interesting because anecdotally, in my time on the council, and of course, I'm well aware that the JNC and the administration do a great job of diligence, and they are attempting to build the best judiciary for the Commonwealth that they can. At the same time, I've heard reasons and issues flagged in people's applications, in their interview process, that to me have nothing to do with judicial discretion, and yet they're used to justify not moving someone forward. On the other hand, we just appointed someone to the appeals court who I voted yes on, and I think is going to be an excellent appeals judge, who had an instance that was well discussed at this hearing of locking up an attorney in an instance that I think all of us that many of us felt was egregious, particularly those who practice law. That to me is an indication, it's an expression of judicial temperament. I didn't think it disqualified him because I believe in second chances, and it was early in his tenure, and I do sincerely believe that looks back on that with regret. So it really troubles me when I hear excuses made that have nothing to do with judicial temperament. It really, really bothers me. But I read in your application, and I'm sorry for that digression, that one of the aspects I'm most proud of is my ability to relate to and empathize with people with various socioeconomic and racial backgrounds and strategize effectively with them to figure out best way to resolve respective concerns. And then you also wrote, in discussing the Jackie Robinson quote you shared, that if I can inspire even a few young people of color to pursue employment in the legal field, it would be a tremendous honor. I'm inferring from those comments that you believe that representation of different perspectives, including race, but others as well, are meaningfully beneficial to the justice system. Am I fair in inferring that?
Absolutely.
Do you think that as we discussed kind of brain development and folks as they grow up being susceptible to the environmental factors and experiences they have, do you think that particularly in juvenile court representation might matter? And I ask because disproportionately, it's Black and Latino boys who are in our juvenile court on particular matters. Do you think representation might be even further important in the juvenile court?
I do.
Because in Worcester, we've had a juvenile court seat empty for 2 years. And cases are backlogging and backlogging and backlogging. So I don't know why it would be so long for that to be the case. I would suspect, given that there's plenty of qualified attorneys of color in the Commonwealth, that the administration is, for some reason, taking extra time to make sure we have that representation on the juvenile court. That's my hope. And that's my digression. I'm going to hold off there, Madam Chair. Thank you for your time. I appreciate your time. I appreciate your patience with me. And I do intend to connect with you between now and the Assembly.
Thank you, Council.
Thank you, Councilor DePaul. To answer Councilor Devaney's question, the reason he applied for Superior Court was because the Regional Administrative Justice for Superior Court in Western Mass asked me to ask him to apply for Superior Court because Judge Callan felt that he would make an outstanding Superior Court judge. In addition, I would indicate that I intended to refer to all of the letters from Judge Danielle Williams, Robert Santinello, who was a justice in the district court, who's known him for a long time, Joe Bernard, who is the dean of the trial bar when it comes to OUI cases, Ron Bailey, who worked with Brandon Freeman for quite some time, 19 years to be exact, and now is a judge in the district court. A.J. O'Donnell, who is one of the finest criminal lawyers in all of Western Mass, if not Massachusetts as a whole, also wrote in support of him, as did Karen Bell, who was a supervisor in the district attorney's office and has known him for a significant amount of time. So I think you're going to make a fabulous judge. And kids, it's a good thing you answered yes, because otherwise you'd be paying your own tuition. Right? So at this time, I would declare the hearing closed. And I thank everybody for their time and attention. And just one other thing, Peachy is the best office manager ever. She was my sessions clerk for years, and well, you know her.
Absolutely.
None better, none better. So thank everybody, and at this time, we will adjourn. Thank you.
Thank you, Council.